now is Gabe Roth, Executive Director of Fix the Courts. Good morning to you, Gabe. So that statement from Justice Thomas that Ariane DeVoe just read, that he said that, he was advised that this sort of personal hospitality from close friends was not reportable. Was there room for confusion here? Because when it comes to hospitality from friends, there is an exemption, right, when it comes to disclosing this on the financial disclosure forms?
Yes, that's exactly right. And thanks for having me. There is an exemption for personal hospitality for food, lodging, or entertainment that takes place on the properties or facilities of a close friend or family member. And I think that reading of property or facilities in Thomas's mind includes private planes. And we know justices in the past have used that exemption. Justice Scalia, for one, has used it many times to go on hunting trips during his nearly 30-year tenure on the court. So it's good that the Judicial Conference, the policymaking body of the judiciary, has clarified that. But at the same time, in the interest of transparency, there's nothing stopping Clarence Thomas from going back and amending his financial disclosures to give the public a better sense of the types of gifts he's been receiving from people who have a clear view on where the court should be heading.
You would think if a justice, at the highest level of the courts, right, serves a lifetime appointment, they're not held accountable because they're not elected by the people, they're not held accountable by the people, that there would be some kind of binding code of conduct that they're required to abide by. But there is no such thing. Is that correct?
Yeah, that's right. There's a code of conduct for U.S. judges, so lower court judges, that's been around in one way or another for the past 100 years and was more formalized about 50 years ago. But the justices have rejected writing and adopting a code of conduct of their own. And the code of conduct is not a panacea. There should be some enforcement mechanisms and some investigatory possibilities under such code. But I think just the larger idea, going back to Thomas's statement, is he said he spoke to some colleagues and others in the judiciary. Well, who are these people? If you asked right now the 9 justices what their ethical responsibilities are, you'd come up with 9 different answers. And that's because the ethics laws that are on the books are vague, and because there is no single ethics code, and there's not even an ethics office at the Supreme Court. The House and the Senate both have these ethics offices. The executive branch has the Office of Government Ethics. So that doesn't even exist at the court, to have a single, everyone singing from the same ethics songbook, both individual person in that office and a code that they explicate. That just doesn't exist. And so we need several different things to happen to bring the justices kicking and screaming into the 21st century of best practices and ethical behavior.
Okay, let's talk about what needs to happen then. And first off, you heard about Democrats calling for Chief Justice John Roberts to, investigate internally. Do you think that will happen?
No. I mean, I hope it does. The Supreme Court Ethics Act, a bill that Republicans and Democrats over the years have supported. Currently, it's only a version of it that was introduced a few months ago is only Democrats, but it would create an ethics office that would have the ability to investigate justices' ethical lapses. And that body wouldn't have the ability to impeach a justice or remove a justice, but it would have the ability to report annually any sort of ethical issues that arose, and the public could then decide what they want to do with those issues. Like, that's not even being that's a bill that hasn't even had a markup or a vote in the House or the Senate yet. I think that the larger issue is that Chief Justice Roberts wants to try to make the court look as great as it can be as this neutral arbiter of the law and of the Constitution. But clearly that's not the case with all these piling on ethics issues. And the fact is his predecessors, when there were ethics issues at the court, took positive steps to change things.
Yeah.
When there was an ethics issue about receiving outside income in the late 60s, Chief Justice Warren Burger required the justices to list their outside income. Similarly, in the 90s, Chief Justice Rehnquist wrote that the justices would be following the gift rules that members of Congress would follow. Clearly, they're not really following them to the letter of the law, but at least there was the attempt to say that they were going to be a part of it. Chief Justice Roberts hasn't really done any of that during his tenure, and I think we've sort of reached a fever pitch where things need to change and change fast.
Well, and it really is eyebrow raising, right? And we didn't even go through the details of this ProPublica report, right? I mean, we're talking about, decades long friendship of a billionaire mega Republican donor, known Republican donor, Harlan Crow, rides on super yachts and private jets. I mean, it makes you wonder, like you said, who these people are, his colleagues that he mentioned, Justice Thomas, and others in the judiciary that he said he consulted with. But in terms of context here, I mean, does that sound just out of the norms to you for a Supreme Court justice to have this kind of close connection to a donor?
It's not super out of the norm. There's, David Rubenstein, who's a big financier, has a program on Bloomberg TV where he interviews the justices and has flown Justice Breyer to Nantucket on his private plane. There's a communications magnate that gave Justice Ginsburg a free trip to Petra, Jordan, a few years back. Justice Scalia famously went hunting with a lot of very wealthy individuals, including an individual, John Poindexter, on whose ranch he died. So there are definitely these engagements and entanglements, and whether or not the justices knew them before they became justices or after the justices, I think that's also interesting, given that Thomas has been on the court for 32 years, but he's only known Crow for 25. So that sort of raises questions as well. But I think just sort of the quantity of the trips, the price tag of the trips, that is unique. In this day and age, it would be nice if there was a Justice Doe on the left that had a similar set of circumstances. So we could do some moral equivalency here and have some, both sides are doing it, so let's pass a law. I mean, that's sort of what makes the next steps hard, is because people are going to want to retreat into their ideological corners when talking about a single justice. But at the same time, Congress does have the power to rewrite the disclosure rules. They've done it in the past, as recently as last year, requiring the justices to post their disclosures online. They used to have to get them via thumb drive, and before that via paper. So, there has been bipartisan action in the past on this. And I think what the headline here is for that would be the justices should follow the same travel, disclosure, and gift rules as members of Congress, which are far more strict than what they're currently follow, and would bring some of these Thomas trips to light more readily, more easily.
Yeah, that seems like a fair proposition, but obviously not an easy road to get there. Gabe Roth, appreciate it. Thank you very much.
Coming up, investigators in San Francisco hope new images will